If you invest in real estate through an LLC, having a solid operating agreement is a must for protecting your investments and defining how your business runs. An operating agreement is your company's Bible, and it can single-handedly determine whether your LLC survives business challenges and protects your assets, or crumbles and leaves you and your business partners suing each other in a lose-lose legal battle. My name is Bishoy Habib, and I'm a real estate attorney. Over the past 12 years, I've closed over 1,000 transactions totaling $12 billion. I've seen many business disputes in my career, and the worst ones usually happen because there's not a good operating agreement in place. An operating agreement serves as your LLC's internal rulebook. While most states don't technically require one, operating without one means defaulting to state laws, which probably don't align with how you want to run your business and can unintentionally create personal liability for you. A well-drafted agreement helps maintain your liability protection by showing courts that you're running a legitimate, separate business entity. Let's break down exactly what needs to be in your agreement and why each element matters for real estate investors specifically. First, let's address management structure. Your operating agreement needs to establish whether your LLC will be member managed or manager managed. In a member managed LLCs, all owners participate in daily operations and decision making. This works well for smaller operations where everyone wants to be hands-on. Your agreement should specify voting thresholds for different types of decisions. For instance, daily operational decisions might need a simple majority of 51%, while major decisions like acquiring property or refinancing might require a supermajority vote of 2/3 or a unanimous approval of 100%. Manager-managed structures designate specific individuals to handle operations. This setup is ideal when you have passive investors or a larger operation. Here, your agreement needs to clearly define the scope of the manager's authority. Can managers sign contracts independently? Maybe they could sign contracts under $100,000, but anything above that requires a vote. You'll need detailed provisions about manager removal procedures and what constitutes cause for removal of the manager. Additionally, establish specific reporting requirements. Monthly financial statements, quarterly performance reports, annual tax documentation, and property-specific metrics should all be addressed. Moving on to capital and financing. This section requires particular attention for real estate LLCs. It needs to address both initial capital contributions and future funding needs. For initial contributions, will you accept sweat equity or property management services? Your agreement should establish clear valuation methods for non-cash contributions to prevent future disputes. I see this all the time when someone comes in with sweat equity and they're going to manage the property, but there's no clear obligation within the operating agreement for them to continue that. So they get the equity on day one, and then if they bounce, you can't really do anything about it. So make sure you don't put yourself in that situation. Your agreement should also establish a clear process for additional capital needs. So real estate often requires unexpected capital, major repairs, renovations, or just opportunity purchases. What happens when the LLC needs more money? Can you force capital calls on the other members? Will they be required to contribute pro rata to their ownership percentage? And what are the consequences if they don't contribute? Some agreements include dilution provisions, while others might convert the non-contributing member's share to debt. Consider including provisions for member loans with predetermined interest rates and repayment terms. Otherwise, it might be difficult to come to an agreement when the members have conflicting interests. The economic structure section defines how money flows through your LLC. This goes beyond simply stating ownership percentages. You need to detail how profits and losses are allocated, which might not always match with ownership percentages. Consider special allocations for tax purposes, or to reward members who contribute additional value through property management or source dealing. Your agreement should establish distribution timing, monthly, quarterly, annually, or discretionary, and specify whether managers can retain earnings for operations or future investments. In real estate, cash flow often varies significantly month to month, so consider including provisions about maintaining cash reserves. Include a detailed distribution waterfall that prioritizes how cash flows to the members. Will some members receive preferred returns? Do you need different rules for operating income versus capital events like a refinance or a sale? Consider including provisions for tax distributions to cover member tax obligations from pass-through income. It also should determine the priority of payments for various costs and expenses, like loans from members. Transfer restrictions are particularly important in real estate LLCs. Your operating agreement should address what happens when a member wants to exit, becomes incapacitated, goes through a divorce, or passes away. I typically advise my clients to include a right of first refusal provision so existing members have priority to purchase available interest. Think about it. If someone wants to sell, you don't want to get stuck with a random partner that you've never met, or even worse, someone you don't want to deal with. Same idea if your partner dies and their spouse or child who has no idea about real estate inherits their membership. You would want control over who you're partnering with. So a right of first refusal gives you that. Consider tag-along rights and drag-along rights. Tag-along rights protect minority members by allowing them to join or tag along when majority owners sell, ensuring equal exit opportunities. Drag-along rights enable majority owners to force minority members to participate in a sell or drag them along, preventing the small guys from blocking a big sale or exit for the entire company. Your transfer provisions should also address forced buyouts. Under what circumstances can the LLC force a member to sell their interest? This might include criminal conviction, bankruptcy, or material breaches of the operating agreement or their fiduciary duty. Include clear valuation methods for these situations, whether that's agreed upon formulas or third-party appraisals. Your agreement needs clear amendment procedures. How can the agreement be changed? What notice is required? What voting threshold applies to amendments? Consider including special protections for fundamental provisions affecting economics or control rights. Include robust dispute resolution provisions, and consider requiring mediation before arbitration or litigation. Specify the jurisdiction for any legal proceedings. Typically, this would be the state that you guys operate in. Include buy-sell provisions triggered by deadlocks. Buy-sell provisions allow for structured buyout of a membership's interest when the members cannot agree on important decisions. It helps maintain business continuity without resorting to costly legal disputes. While no one expects disputes when forming an LLC, having clear procedures helps resolve them efficiently if they arise. Think of it like life insurance. You don't buy it hoping to die, but it's there in case you do. Establish comprehensive requirements for maintaining books and records. What reports will members receive? How often? What access do members have to examine records? Clear reporting requirements help prevent disputes and ensure everyone stays informed. Consider including specific requirements for property level reporting, capital expenditure tracking, and return calculations. Your operating agreement should also address specific real estate concerns. Include provisions about property management, leasing authority, and maintenance responsibilities. Address how insurance decisions are made and who's responsible for maintaining appropriate coverages. Consider including provisions about 1031 exchanges and how to handle purchase options or rights of first refusals on property. Keep in mind that an operating agreement is not a set it and forget it document. You should review it as your business grows. What worked for a single property or back in the day might not suit a larger portfolio. I can't tell you how many times clients have had the same operating agreement for 10 or 15 years, and most of it is not even applicable to what they're doing today. Work with an experienced real estate attorney who understands real estate investment, who can craft an agreement that protects your interest and supports your business goals. Remember, the time and money spent getting your operating agreement tight pales in comparison to the potential costs of operating without one or with a poorly drafted one. This document forms the foundation of your real estate business, so make sure it's done right. If you like this video and want to learn more about real estate investing, hit the like button and let me know in the comments what topics you want to learn about next. Thanks for watching, and don't forget to subscribe for more videos every week.